gracious enough, he did this 4 years ago for us, gracious enough to do it again. So after his brief introductions, Steve will start asking some questions prepared. We'll get far enough into the time. We will open it up for some questions from the NPA members who are here, the journalists, the editors, publishers, and reporters who are here. And then we're going to have, try and reserve a few minutes at the end for some closing statements. That's all right with everybody. You want me to flip a coin to see who introduces himself first? Ross, Colin? Heads? Just like the Super Bowl? Heads it is. He'll go second. Okay.
Thank you, Nevada. Can everybody hear me now? Okay. Well, thank you to the Nevada Press Association for hosting this debate. As many of you know, we've been looking forward to debates since January, and we encourage you all to keep pressing for debates in this race. I think the Attorney General's, oh, actually, first I want to introduce my wife, Jamie, here in the front seat, and thank her for all her support this year. Many of you know how challenging it is running for office, and we have an 18-month-old baby at home as well that makes it extra difficult being on the road. But my baby's name is Sophia, and as I said, she's 18 months old, and this is the primary reason I'm running for this office. There's no question that there's deep concern around the state and indeed around the country of where we are heading. And the Attorney General's office is one of the most unique offices where I can work on from day one two things that I think families and our communities care about most. And that is our security and our prosperity. And I believe my background, which I'm sure we'll go in hopefully in the debate at great length, but someone that came out of Georgetown Law School and was a Navy JAG officer, and someone that's been a prosecutor, someone that's been a legal advisor in major circumstances, including overseas in Iraq, someone that was nominated to be a professor of law at the U.S. Naval Academy, and finally someone who has a lot of private sector legal experience as well. This broad range of legal experience, I believe, makes me the most qualified for this job. And my vision, which I've laid out this year, is something that hopefully we'll talk about today. But we need a vibrant, active office, and we need an Attorney General that's going to work hard every single day, something I've done every day of my adult life. I've done nothing but succeed and accomplish the task I've set out to do. And Nevada needs that Attorney General this year, and I look forward to being it. Thank you.
Well, thank you. I'm thrilled to be here, and I want to thank the Press Association, who has always historically recognized the importance of this debate. I think highlighted by the fact that they scheduled us to immediately conflict with college football and Saturday morning cartoons this morning. My daughters were going to come this morning, but it conflicted with a new episode of Dog and Block, and so I think that puts it all in perspective. But you know, what I love about being Secretary of State and now campaigning for Attorney General is that both of these jobs are essentially about solving problems. I didn't get into public service to get involved in partisan disputes and ideological disputes. I got in this to make a difference for Nevadans. And we have real problems that need to be solved by an Attorney General in this state. We have scammers who come to our community who try to prey upon the aging population, who try to rip these retirees off everything that they've saved so hard in their lives, prepared for their retirement. We have sexual predators who come to our community and refuse to come into compliance with our registration laws so that the cops can keep track of where they are, to keep them from reoffending and abusing our kids. And since we're living in a digital era, we have real tension between the interests of privacy of the individual and the private sector, and making sure that law enforcement uses the data that they need in order to test the data. We need an Attorney General who understands that balance and can make sure that we maintain personal private sector has the information that they need to thrive, and that law enforcement, at the end of the day, has the means to get the information they need yesterday. I have experience solving real problems. First, as a criminal prosecutor, working on the front lines, trying and convicting everything from murders to child molesting. Working on the front lines of keeping our community safe. Then as Secretary of State, as Chief Elections Officer, cracking down on election law offenses and imposing record fines and penalties to members of both parties. And then as head as a security committee, making sure that we go after those scandals, imposing lengthy prison sentences, and recovering millions of dollars in restitution. And when time comes up in my office, I'm proud of the actions that we put forward. Cutting our office budget by over 29%, while at the same time adding additional services, increasing revenue to the state so that we can fund our essential services, and giving back part of my salary so they can fund the general fund. Like many of you in this room, I love this state. I was born and raised here. Born here in Las Vegas, raised for the most part northern Nevada. Leslie and I raised our 3 kids up in northern Nevada, and I believe the Attorney General's office is poised to make a real difference in this state. That's why over 4,000 cops and prosecutors across the state have endorsed my campaign, because they know that I'll put them back, not personal politics or ideological disputes first. And that's why I'm asking for the votes. Thank you.
All right. My name is Steve Sebelius, and I too am running for Attorney General. No, I was going to do it right up until I said, you have to work hard every day. And I said, this is nothing. I want to thank Barry, of course, for inviting me to do this again, and assure all you Press Association members, I have seen Barry late at night in the legislature, working the halls. He does not go brick at all. So thank him for all he does in the legislature to help the association. And I want to thank both candidates for being willing to come out and do this and miss those cartoons. I'll personally be watching those cartoons. I get my phone, multiple they answer questions, so I won't miss out on anything. Normally what I do to start this off is I ask each candidate if they could name all of the 5 distinct freedoms that are encompassed in the First Amendment. I am reasonably confident by now that this trick has been well known, and I think both are prepared for that. So we're going to go to the Fifth Amendment this year. We're going to start with some questions that are particular of interest to the Press Association and open government, open records, and we'll move on to some questions of a more general nature. So one thing that I've noticed, and this has become a pretty significant problem for access to public documents, is that when it comes to requests for public records, government agencies typically tell news organizations that there's hefty fees just to gather the information so it can be examined by a requester. To say nothing is copied. So there was one television station in town I'm familiar with who made a request of the Clark County School District for records. It was presented with a bill for $11,000 just to see the records, not necessarily to inspect. So my question is 2 parts. First, do you think those fees are legal to charge? And secondly, do you think they constitute a barrier to examining those public records? How do we go first and then
It was my understanding that our openings were 2 minutes, so hopefully you'll let me steal back a few minutes here.
It seemed
sometime during the debate.
Just seconds, so it flew by.
I'm sure. You know, I think that transparency is one of the most important issues we face as a state and as a community. I think one thing the Press Association does an exceptionally good job is holding government's feet to the fire. Elected officials are representative of the people, and our government is of the people. And there's nothing more sacred than making sure that backroom deals aren't happening, and you know that government is not simply picking winners and choosers. Transparency is absolutely essential, the open meeting law that, again, that the Press Association fights so hard for is crucial. And, you know, I will say that I will certainly fight as an Attorney General to make sure that the Attorney General's office is vigorously reviewing these open meeting requests and making sure that that's a priority. As specific to your law, I'm not really sure. But I can say that I am very concerned that, you know, when you have my opponent who's been in office for 8 years and has shown a pattern, I believe a reckless pattern of taking gifts, up to $70,000 in gifts he's taken as an elected official. You know, this is the kind of thing that concerns me, and I think it really makes people wonder whether their government is working for them or whether their government works for special interests. And transparency is the absolute key to make sure people have faith in their government.
But just to follow up, so you're not sure if those, as far as you're concerned, those fees that they charge are legal or not?
I'm not sure.
Okay.
Those fees are not legal, to set the record straight. And I have history with this. And this is an important issue. Maintaining transparency in government is one of the most important things that we can do to encourage the public's faith in our government. And the state and the press are an essential component of that. So we have to make sure that they get the records that they need, which are truly public records. And I have a history of doing it. I've championed transparency more so than any other Secretary of State in history because I recognize that importance. But there is actually a statute that was passed last legislative session that outlined a fee structure and how much agencies are allowed to charge in order to be able to obtain these records. It didn't extend to local governments. I think we've got to go back to the legislature and make it extend to local governments. Individual agencies are also able to set their own policy. And I have experience of showing the cooperation that we're willing to undertake as Secretary of State and how I'll serve as Attorney General, because we have a policy in our office that if any member of the press requests any of our records, they're not charged. And we do that as expeditious in as quick a time frame as we possibly can. My opponent mentioned the gifts. I'm not sure that fits the question, but let me address that anyhow. Because the entire reason that that's out there is because I went above and beyond and disclosed these items, which many other elected officials in this state aren't doing. And so that's out there as part of the public record because I wanted the public, the press, anybody that wants to look at it to have the right to know. And he has completely mischaracterized those gifts and packed them upon a bunch of lies. And I'd be happy to address it in a question that actually fits, but this question was actually about how you deal with public records. I have a track record and experience in turning those over. And in fact, when my opponent and these dark money groups came into my office and requested thousands of pages of information, and maybe every piece of paper that we had ever produced, we turned them over as quickly as we possibly could. Because in the interest of transparency, those are public documents. And I want the public to be able to evaluate those documents to see if there's anything in those documents that would bear on whether or not I'd be qualified to become an attorney. That's the stance I've taken as Secretary of State. I'll take that same stance as attorney.
So just to clarify, we all go back to the legislature and set a fee schedule, not just for the copy of the public record, but also for the county, whatever records they respond to the public record request.
Absolutely. And that's already set within state law for executive agencies. For whatever reason, they didn't extend it to local government. So the example that you mentioned, it didn't apply because that was a local government. And they should be held to the exact same standard. And I can tell you as somebody who's had probably more records requests than anybody in the state, with these out-of-state groups coming in, want every piece of paper, it is a burden. It shuts down the office to try to go and collect every piece of paper that's ever been produced and do that in a reasonable time frame. But I was happy to do it. And it's now part of the public record because my office saw that as a priority to put that out there and disclose absolutely everything.
We'll switch the order, and Mr. Miller, you'll get this question first. The fees that are involved in copying public records are still fairly high. NRS 239.052 specifies the fee charged for making a copy of a public record, quote, must not exceed the actual cost to the government agency to provide a copy of the public record, unless a specific statute or regulation sets a fee that the government entity must charge for the copy, end quote. Either the law be changed to set a maximum fee, say 5 or 10 cents a page, as was proposed by Senator Segregated draft in his legislation,
absolutely got to set a standard in place that makes it reasonable and work with all the stakeholders to figure out what that is. I can tell you, after having gone through this the last couple of years and dealing with these out-of-state groups that have requested thousands of pages from my office, there's a real cost to it. And it requires a lot of personnel to drop everything that they're doing, to set aside the priorities that I came into this office to try to accomplish so that we can fulfill these records. And so we don't want to have a standard in place that allows for people to just shut down government by asking for these papers and just not, and only charging a nominal fee. It's got to be reasonable and there's got to be a balance. But I think the current system works. It can always be revised and improved, so we should take another look at that.
Well, as I stated initially, transparency is essential for government, and there's a reason we have these open meetings laws. And I'm happy to roll up my sleeves, as I did in the military. I've done every day of my working life. I've always gotten these problems resolved. And, you know, I believe this is why I have the endorsement of the grand majority of elected sheriffs and DAs in this state. These are DAs that I went around the state over and over and earned these endorsements because I know I'm going to work hard and I'm going to get results in this office, something that I've always done. And so, you know, all I can pledge to you on this specific, very specific issue, and I commend you for it, is, you know, we'll do what we can. Governments need to make sure their records are available to the public. That's a very important function. I understand the fees. I just don't know what's a reasonable fee, and I don't want to speak out of turn unless I've really reviewed it and what these things are costs and what kind of burden they correctly are.
Okay, well, Mr. Laxalt, the next question goes to you first. What penalties, if any, do you think ought to be added to NRS 239.0107 for government entities that fail to produce public records within 5 business days established by law, or provide a written explanation of why they cannot do so? Do you think there ought to be a penalty if the government misses that deadline when a request is made by a member of the public or member of the press?
Well, you know, currently, if these open meetings laws are not followed, there's misdemeanor, there's both civil and criminal sanctions available, and I'm not positive how this applies when they're 5 days late, but it's something that we should look into. I believe it's a little bit more of a policy question for our legislature to figure out, you know, whether they want to add a stiffer punishment onto beating or losing the 5-day deadline.
You're talking about civil criminal penalties, no beating.
Right.
This is the public records law that I'm talking about.
I understand.
So there's no.
I'm just trying to make the analogy that I know it exists for those, and I'm not.
There should be a penalty for violating that law.
I think we'd have to look at it.
My opponent has clearly demonstrated that he doesn't understand the difference between the open meeting law and public records, and that's key. I do. And so here's the way I think we should address public records and failure to fulfill those requirements. One, we've got to put more clarity in the law. We don't have that. We don't even have a statutory definition of what constitutes a public record. And so it's not clear to the public as to which records have to be kept. Two, we have to educate these agencies as to how you fulfill these public records. And then three, we've got to have stiff enforcement. That means giving the Attorney General's office greater ability to get in there, issue subpoenas, conduct investigations, and hold individuals accountable if they're not meeting the requirements. That can include civil or criminal penalties if it's a willful violation. I think that's the only way to address this and make sure that we get that out in front of the public. I hear my opponent talking about the fact that if he takes office, he's going to make this a priority. But since he mentioned the gifts, let me just suggest to you, he's been sitting on military records and his personnel file suggesting in numerous media reports that he didn't have them. It turns out he did. He'd said there was nothing but glowing reviews in his personnel file. That wasn't the case. And now all of a sudden he comes forward, cherry picks a couple of military records. If he's so committed to putting this information in the public so that the public can make an informed decision, why doesn't he turn those over? And the fact that he hasn't there so the public can make an informed decision. I encourage them to push those records out there so that we can make an informed decision on whether or not these belong.
All right, now we will turn to the open meeting law. Under the open meeting law, as Mr. Laxalt noted, there is a penalty that if a public official is found to have violated the open meeting law intentionally, he or she can be removed from office in a proceeding that the Attorney General could bring. First down to Mr. Miller. Why do we never see, although notwithstanding numerous reports of violations of the open meeting law, why do we never see a prosecution initiated on that basis?
We need more aggressive enforcement. And I commend the current Attorney General for taking steps to get us there. We saw only a couple weeks ago, she stepped in and took an aggressive approach with the Washoe County School Board, initiating an investigation, ultimately holding them accountable and imposing fines. That didn't happen by accident. That happened because she worked with the legislature to try to enhance the tools that the Attorney General's office has in order to be able to conduct those investigations. Going to the legislature and asking for subpoena time. So when they got a complaint about what had taken place up there, they went and conducted interviews and they issued subpoenas so they can get a hold of text messages, get a hold of cell phone records to determine whether or not a violation took place. It's imperative that we do that we hold these individuals accountable when they refuse to comply with the open meeting law and run government in a transparent manner. I've got a history as Secretary of State that I can point to of doing just that, of cracking down on members of both parties and holding these individuals accountable. These are tough deals. You have to get in there and try to take enforcement actions against your colleagues. Sometimes these people are your friends. They be members of your own party, members of the other party who are going to be accused of playing partisan politics. I've got a long track record of doing it, going after organizations that were aligned with the Democratic Party, imposing record fines in the last gubernatorial campaign on both sides. And so when it comes time to enforce the open meeting law, I intend to be very aggressive, and I will uphold the law in as aggressive manner as possible.
You know, first I'd like to address to Ross who I am and what I stand for. You know, I think it's rather appalling that he would ask that question. I'm someone that out of law school decided to volunteer to serve my country. I went to Georgetown Law School. I could have gone to the DA's office like Ross did and started climbing my political career and walked my way up the ladder. Everyone knows the DA's, assistant DA's office is your entree into politics. But that's not what I did. I decided to join the U.S. Navy. I decided to join the U.S. Navy at a time when 15% of people were being accepted into the JAG Corps. And of all of us that were accepted, we knew there was a huge chance we were going to be deployed to a war zone. So what I stand for is service, and I know he can't understand how anyone would ever challenge him for this office. I understand. I hear that. I've heard that since day one. But I'm here because I want to serve this state. I want to make a difference. I have a legacy in our family that is of service. Service to make this state, since the 1850s and 60s, we have done in every industry in this state. We've made Nevada a better place. That's why I'm serving. You know, I could have run for any office on the planet. I'm running for this office against this guy because I think I'm going to do a better job.
Service, and if you were to manage to get into this office, do you think we ought to prosecute and remove from office violating the open meeting?
You know, I'm restating what I said initially. I think there's no more sacred trust to government to make sure that people have access to what's happening behind the curtain. And these laws make sure that you cannot have deals made by a county commission or a city council behind closed doors. They're there for a reason, and we've worked very hard to make sure they're in place. The Attorney General has a prominent role in enforcing this and indeed investigating, like Ross suggested with the Washoe County situation. We need to be fast, we need to be reactive, we need to be willing to investigate and issue subpoenas. I agree with that. And you know, if the offense is blatant enough, certainly we need to look at criminal punishment.
And so, Dr. Mr. Miller, don't you think that if one or two public officials were removed for violating this,
said this from day one as Secretary of State, when I campaigned on a platform of ensuring that I would come in and crack down on election law violations. And I use this as an analogy. Because those kind of violations have gone on for too long, completely ignored. You know, I promised to come down and crack down. First thing I did was form the Election Integrity Task Force, a multi-jurisdictional task force that involved law enforcement representatives from every agency in the state and federal officials. And we held a press conference, and we said, look, we're not going to stand for these kind of violations moving forward, and we're going to go after them aggressively. We cracked down on April, even though that was a Democratic organization. I led the investigation that ultimately resulted in a raid. The only organization we are the only state that charged that organization with criminal penalties for which they were ultimately convicted. That sent a strong deterrent effect to organizations throughout the country. It's a battleground state. You can't come out here to Nevada. This isn't the old Wild West, and just run over us without any fear that we're going to step in and go have to be aggressive in our prosecution. We didn't see those kind of activities in future presidential elections. That's the same thing we need to do with these kind of violations. If you step up or you see an egregious violation, hold those individuals accountable, go after them for criminal or civil prosecution, and potentially removing them from office in the most egregious cases. You won't see that kind of activity happen. Deterrence has that type of effect. That's what I'll do with deterrence.
Mr. Laxalt, this one refers to you. There is a deputy in the Attorney General's office assigned specifically to police open meeting law violation. If elected, do you think you could assign a deputy police violation of the public records and give the public some person to turn to if they feel that they've asked for a record and been improperly denied?
Yeah, I'm aware that there is someone permanently assigned to that, and someone that we do need to get moving, get I believe, working more effectively to track our meetings and make sure that every time these are happening, that the rules are being followed. It seems to me that it could be a natural fit to whether we add an additional deputy or make someone dual hatted that we could do this. There's 200 lawyers in the AG's office, over 300 staff members combined, and so you get in there, you got to prioritize and make sure that the job's getting done on all fronts. And there's certainly a lot of areas where the job just isn't getting done right now.
Would that be a priority if you're elected?
It would be a priority. I mean, I think in both, we keep talking about both of these situations, and it is one of the most important reasons for me to run for office is to represent the people and make sure that this grand frustration that exists around the state, that government is no longer for the people. The government is ran by a handful of people that feel entitled to office, and they feel like they get to serve just because they get to serve, because they've been there. This is the kind of thing that I think that the public is totally frustrated with. They don't think that our elected officials are actually accountable. And this is one of the main reasons I'm running, and it's one of the main reasons, again, why I look forward to being a partner of Governor Sandoval, why we have these incredible endorsements from the elected DAs and sheriffs. My military background, when I swore the oath to be a naval officer and a JAG officer, you are the most nonpartisan enforcer of the law that you can imagine. There is no politics in the military. And this is what I bring to this office. I look forward to fighting for Nevada.
What do you think that being assigned police public records violations?
We should absolutely have a deputy who would be assigned to police public records violations. And not only that, we should then investigate the resources to make sure that they're following suit. This poses, acknowledge that this poses a bit of a conflict because the Attorney General is also responsible for representing and defending all of those agencies. But you can impose a Chinese wall. They do it repeatedly in all different kinds of contexts. And so what we need is somebody for the public to be able to go to, an investigator with the AG's office that can go to that agency and say, here's the request. Why isn't it getting filled on time? Because otherwise, they're stuck having to go to the courts. And that's not a realistic remedy. They need somebody immediately that they can turn to that investigate, try to get an answer, and push back. And I think if we do that, we'll see these records be fulfilled in a more timely manner, which ultimately will give the public access to the information that they need on a timely basis.
We'll move now to some of the more general questions. Twice during her tenure, the current Attorney General, Captain Ordnance Masto, refused a direct request from the governor to initiate litigation, notwithstanding the fact that the law says that the Attorney General must initiate litigation with the governor so that arrest. Specifically on the Affordable Care Act, Governor Jim Gibbons asked Attorney General Masto to join the lawsuit against the federal government that filed by 25 states to seek to overturn the Affordable Care Act. The Attorney General refused, saying first that it was Nevada had no practical interest different from the other states, and so that it needed to go on. Second, that it was frivolous litigation. This question first, Mr. Mill, do you agree with her decision, and would you have done the same in that circumstance?
It's hard to address what I would have done hypothetically without the benefit of the attorney-client privilege discussions that the Attorney General at that time had with the governor. I know from reading her public statements that what she indicated was that she conducted a thorough review of the law. The governor had directed her per that statute, which makes it very clear. The governor directs the Attorney General to file a lawsuit, defend against the lawsuit. The Attorney General shall file a lawsuit. She conducted a thorough review. She talked to the other states, 17 to 25 of those other states that had joined in on that lawsuit, to get an understanding of their legal reasoning. And she cited to an ethics statute that says, I have an obligation to only bring cases where I think there's a good faith basis to win that lawsuit. Obviously, with hindsight, we know that with a split decision, there was at least some legal basis to challenge the Affordable Care Act. What I can tell you moving forward is that that statute to me is entirely clear. And that statute says, if directed by the governor to file a lawsuit, that the Attorney General has the mandate to do. I've got a strong working relationship with the governor. I intend on having that relationship with him moving forward. If these issues come up in the future where I'm directed to file a lawsuit, I intend to consult with him about any legal issues that are out there and ultimately work with him to try to take his
You don't think that the ethics statute that the Attorney General cited trumps the statute that says the Attorney General shall initiate litigation?
Again, it's tough to address hypotheticals. Obviously, there could be some situations, not very often. The bottom line for me is that the statute makes very clear that I am directed. If the governor so directs, I'm required to file a lawsuit. And only in the rarest of circumstances where I truly believe that there was no legal basis, and I don't anticipate that happening, but if that did happen, there's other avenues to bring in an outside case. But I would not anticipate that happening.
Mr. Laxalt, we agree with the Attorney General refusal in that case, and what would you do in that circumstance?
No, I really don't think it's that hypothetical at all. You guys follow Obamacare every day as that was coming down the pipe. There were a lot of attorney generals that had filed a lawsuit. The governor wanted this attorney general to file a lawsuit, and the lawsuit should have been filed. The notion that there was no good faith argument obviously falls on its face, given that it went to the Supreme Court and was a very split decision in many different ways, actually. So absolutely, it's the job of the Attorney General to file a lawsuit. If the governor orders it, that's the law. And it's important that the Attorney General enforces the law in a non-political way. Whether I like a law or don't like a law should never enter into my equation. People are concerned about what's happening to the rule of law out there, and they think that whether it's judges or now this new trend of attorneys general, they're making the law hyper-political. And it's something that I pledge to not do. There are going to be laws that I personally don't agree with, that if it's my job to enforce them, I will enforce them. I do want to say that Obamacare is the first such situation, but the importance of the Attorney General's office in being willing to use this office to work with the governor to protect our state from a federal regulation that can decimate our jobs and our economy is essential. Not only should MASTO have filed that lawsuit, we need an Attorney General that is going to be looking for opportunities to protect our economic vitality. Obamacare is one. I've talked to a number of you and on the road about sage grouse being the next major one, where we need to have an AG that's going to be willing to file that lawsuit, that's going to be willing to try to hold up the listing of that sage grouse, because what that will do, it may sound esoteric to some people, but it is going to cost lots and lots of jobs. The thing that the governor works every day, as we all know from this past week with his advertisement, he has added so many jobs to the state, working hard every day. And I look forward to being his partner as Attorney General, working for other avenues to make sure we are adding jobs to this state.
Just can you foresee any circumstance where you would not file a lawsuit if the governor directed you to do that?
No, I cannot, off the top of my head.
Do you think the Attorney General, and this is first to you, do you think the Attorney General is obligated to defend every law passed by the legislature? Are there any exceptions? Are there any laws that you think the legislature passed that you would not defend it on ethical, legal, or any other grounds?
I mean, if there's something that I think is unconstitutional, either by our state or U.S. Constitution, then that's a legal analysis that needs to go into that. But last thing I want to do is send a signal that I'm going to be looking for avenues to not enforce the law. I think we need to send the opposite signal, that Attorney General needs to be relied on to enforce the law, to be apolitical, and make sure that people can rely on that person to just be that enforcer of the law. And if there are certain circumstances where it's a heavy law enforcement issue, and I feel like with the sheriffs and DAs and other law enforcement around the state, that it's something that's making our community less safe, something that's really hurting the most vulnerable in our society, then you take an active role and you use one of your bill drafts and try to change it. But I don't think it's appropriate to just use the office and kind of manipulate the law to make sure it fits what you think it should be.
You said something interesting at the very beginning. If there was a law you thought was unconstitutional, now we agree that you know all the laws passed by the legislature presumptively unconstitutional until they're found otherwise by a court. But if they passed something you really thought was unconstitutional, you would go to the district court, the Ninth Circuit, you would defend it.
No, like I said, if it was something that I felt somehow was unconstitutional, I have to very much evaluate that and see whether or not there was a challenge that needed to be made to it.
Mr. Miller, what do you think? Are you obligated to defend every law the legislature passes?
The Attorney General is the state's top attorney. That individual has to be true legal. You have to look at every issue with a deliberative mindset, to look at all the constitutional issues that may be out there. That there obviously, as you mentioned, the presumption that law may be constitutional. But we can certainly envision statutes that are put in place that would be clearly unconstitutional. And faced with those, I wouldn't defend these. If the legislature passed a law and required somebody to wear a star case, or as we had a suggestion from one legislator that if his constituents wanted, he would reinstitute slavery. Those kind of laws, obviously, I would fight to uphold the Constitution of the United States, because I'll take a duel to this morning to uphold the laws and the Constitution of the state of Nevada, but also of the United States. And it's incumbent upon an Attorney General to show that kind of leadership, show that kind of legal analytical skills, to be able to step up as a leader when those types of situations arise and challenge those unconstitutional statutes.
This question first to Mr. Miller. Your opponent, up to and including this morning, has criticized you for accepting gifts while in office as the Secretary of State. He has said that he will not accept gifts at all in office, although he wouldn't go so far as to say that there should be a blanket policy that prohibits all gifts. First part of the question, do you think that elected
he brought us up, because they have spent nearly $1 million in this campaign with out-of-state groups trying to completely mischaracterize this issue in line. And I encourage the public to look at the substance of what's been reported. I have gone above and beyond to disclose absolutely everything about it, including things that probably didn't need to be disclosed, because we don't have clear guidance in the statutes as to what needs to be disclosed. The overwhelming majority of the items that I reported as gifts really constitute educational opportunities, even a Department of Defense sponsored trip. One that they made a big deal out of was a trip up to Aspen. That was in reality sponsored by the Aspen Institute, where they selected 24 of America's top rising stars to study principles of democracy in an effort to reduce partisanship. It was an educational opportunity. I became a better leader because of it. And I reported, despite the fact that elected officials across the state don't often do that. The overwhelming majority of the gifts that I reported also are participation in Visits International, which is the world's largest CPO group. They give me tuition so that every month I can go and sit with business leaders and learn about their issues and try to become a better leader. Charity banquets. These aren't gifts in the traditional sense, but that's why I put them out there, and that's why I've gone above and beyond to try to disclose this. Because at the end of the day, I want the public to be able to make an informed decision as to whether or not they think it has any bearing on them. And so I'm disappointed that they continue with these lies and misrepresentations, because I've fought so hard for transparency. I've done more than any Secretary of State in history to try to disclose absolutely everything, demanding more reports from our elected officials, and mandating that there's a single filing office where you can search and categorize these things online. And on the issue of gifts, I've sponsored legislation every cycle to try to put clear definitions in the law of what is or isn't allowed. It hasn't passed, but despite that fact, I've gone above and beyond and disclosed absolutely everything so the public can make it.
Laxalt, the idea, I guess, that is overseas gift, they may be influencing their office. Is that not obviated by disclosure? Once that gift is disclosed, the influence thereby is somewhat less. So if he has disclosed all his gifts, as he said, then and the law allows them to receive those gifts, is there really anything there? Is there really any problem?
You know, when I was a JAG in the U.S. Navy, I had to be an ethics officer, and questions were asked all the time. What can service members receive? You can imagine these guys coming back from war. You know, people wanted to buy them things. People wanted to do all this stuff. What was the rule of the Department of Defense? No gifts, period. In fact, a very hard rule to pass on to these guys. 19-year-olds, all people want to do is make their life a little better. Why does the DoD have that kind of policy? Because receiving gifts, they believe, gives the public the appearance that this office can be bought. And being an officer, enlisted member of the U.S. military, we can never afford to allow the public to think that the military can be bought. It's a very slippery slope, and it's one they've got a very black line for a reason. And I think it should be the same reason certainly for the Attorney General's office. The Attorney General is the top lawyer for the state. We advise state agencies. We're involved with all of these companies. And if I were to accept $70,000 in gifts from all of the primary companies and lobbyists in the state, it would be fair for the public to be concerned that these are all my friends first, and that, why would these people be taking me to boxing matches and to all these events? I mean, Mr. Miller here says that it's mischaracterized. There's nothing mischaracterized. These are gifts. They have been taken. They have been used. And I beg to differ that they are important. I want to leave you with a very stark number. When I look back, Governor Sandoval took $0 as an Attorney General. Maxta was taking less than $1,000 in 8 years combined as a sitting Attorney General. This current governor, as the governor of the state, who I'm sure has just as many educational opportunities as Ross would characterize him as the next guy, correct? he has taken less than $1,000 of gifts in the governor. So I say $70,000 of gifts. It's just so outside the lines. If it was $500 or $1,000 here and there, so be it. But I've pledged to not take gifts because I think it's important for this office, above all offices, to absolutely never be beholden to special interests in this state. That's something I will do.
Given that, given the importance of images and the rationale behind the DOD policy, why would you not want that to be a part of the federal? Why would you not want that to be a law? And pass a law that says nobody if they're elected to office because of the perception or reality that the office will be.
It's a great question. I will work day one as a pledge as the sitting Attorney General to pass a law, one of my 15 bill drafts that absolutely exempts the Attorney General's office from taking gifts. I think it's a starting point. Bans. That bans the Attorney General's office from taking gifts. So.
Well, why not do it for the entire, if it's that, why not do it for the entire legislature, all constitutional officers, every public official?
You know, I'm running for a very serious office. It's my first time running. I believe in the rule that you lead by example. That's something I did as an officer in the U.S. Navy, something I did in Iraq. You had to make sure that you did the right thing and hope that people will follow. And I think that the best way, rather than go out there and have a bunch of fighting about this, is me lead by example, set the stage with this office, and in a few years, hopefully a number of other people will start agreeing that this is the way to go.
So the only way is, well, let me ask you, first to start off, I'm sure you're the question of what you want to make. Should there be a ban on gifts? Should it just be a flat ban on gifts?
Absolutely, there should be a ban on this. That's what, in fact, what I proposed last legislative session, was try to put in the statute a definition of what does or doesn't constitute a gift. We're getting away with this blanket term of using gift. What I put in the statute was to make it clear, look, educational opportunities paid for by nonprofits aren't gifts. They may, in certain circumstances, still have to be disclosed. But they're not gifts in the traditional sense of the word. If you attend a charitable function, is that a gift? Can you receive it? I proposed legislation that's been in place in many other jurisdictions because we needed clarity. And make no mistake, when Mr. Laxalt talks about the governor not receiving gifts, the Attorney General only receiving 1,000, and his numbers way off on that, incidentally. And other elected officials not receiving gifts. That's entirely misleading. There's plenty of ways to hide these items of value if you want to do it from the public's view. You can pay for them with campaign funds. You can just not report them and say, I don't think this is what constitutes a gift. We've seen instances of that just in the last several months. People taking trips to Israel and other places and saying, not reporting it on their gift report. When somebody points it out, they say, oh, you know what? I'm going to go ahead and admit it. The reason that the public knows about these items of value that I received is because I went above and beyond and disclosed it. But we have to fix it because this goes directly to the public's confidence in the electoral system and their elected leaders. That's why every legislative session I've made it a priority to fix this problem, to define gifts, make it absolutely clear who can receive gifts, under what circumstances, and what type of gifts, and how they should be reported. That's the kind of leadership you would expect from me as Attorney General. That's why I take the extra step to disclose absolutely everything. And that's why it's so frustrating to listen to these attacks and lies from these dark money groups, these hypocrites, who come to this state, run these attack ads with these lies, and themselves refuse to come into compliance with our transparency statutes. They want to run these attacks and themselves not come out and tell us who's funding these attacks. And for him to sit idly by and engage in this and use this as an attack and suggest that there's something wrong with what I'm doing, while at the same time not saying, no, we should bring them out of the shadows and the public should have the right to know, I think that's absolutely disgusting.
All right, we'll take one question from the audience before we go to the candidates' closing statements, which I'm sure will be lively. And it's from another Steve. Only Steve get to ask questions. Friday. Steve, Alan, go ahead.
Okay, good morning, gentlemen. Steve Ranson, I'm editor, general manager of Law and Values in Fallon, Nevada. We've met numerous times your election, the governor's election, all the other statewide offices are important. I know in the rural counties and what I've read out of the Review Journal, and also the Gazette Journal, that education tax, initiative tax is probably the most important thing that is really affecting us right now in terms of if it does pass, for example, will it be legal, not legal. Many of the unions now come out against it. Our school board and superintendent have come out against it when it could benefit them, but the way it's been set up, that money can be earmarked for anything according to our legislature. But my question is how do you feel about the tax, and if there's anything, loopholes or whatever it does pass, if it is.
Yeah, the margins tax is one of the worst ways to do business. We do have an education problem, and unfortunately, I don't think this is going to solve it, and I'm at least personally opposed to it. I do know that a lot of business owners are concerned about the margins tax, and they're worried about the front line 2%. But they're also wondering, there's enough ambiguity in the statute of whether or not it applies to all their subsidiaries and all of this sort of secondary parts of their business. And that's going to be a good avenue for an Attorney General to look very seriously to see if in fact it does apply. And I plan on looking very seriously at that. And ideally, we try to blunt the force of this margins tax. But I do want to quickly get into. You're going to do it on closing? Okay.
One of the things I'm most proud of my tenure as Secretary of State is that I have worked very hard to make sure that I don't put my fingers on the scale of the electoral process, and that includes my oversight over the initial petition process. I have never taken a position on any initial petition because this office oversees the fourth branch of government in this entire initial petition process. So I appoint the ballot members that write the arguments for both sides. I make the review as to whether or not those ballot arguments have any misleading language. I ultimately will certify the election and run it in as fair a manner as possible. And so I have always taken the position that I can't weigh in on the policy for or against any of these items that are right before me. It would be just like a judge telling me his personal opinions about a case that was coming before. And so I have never taken a position on any of those issues. I can't today.
All right, so no, abstain. Sorry, Colin, the answer is pro. Sorry. All right, we'll do closing statements. We'll do them in the same order. So, Mr. Laxalt, first.
Well, I'm very concerned about the conflict of interest, and Mr. Miller just mentioned that he's a champion of watching for conflict of interest. And I want to turn everyone's attention to, keeps pointing to dark money. And when one of these outside groups came in with an attack ad, he responded by saying he was going to pound his fist, shut them down. When asked about the U.S. Constitution and whether he was violating the U.S. Constitution, he said basically he didn't care because he had a bigger agenda that he wanted to push. So what I suggest to you is you make sure you keep his feet to the fire. The Democratic Attorney General Association has recently put out a purchase of $1 million in attack ads against, guess who? Me. And let's make sure that Mr. Miller will be the champion of bipartisanship, and he will sue them, call TV stations and tell them to stop running the DAGA ad. Let's make sure he really is this great bipartisan champion of transparency. I also think that as someone that we want to lead as the top lawyer and top law enforcement officer in the state, for someone that people want to be able to trust, for him to take this gift issue and actually act like that he's now somehow to be emulated because he's reporting all of these gifts and simultaneously try to take down Captain Cortez Masto and Governor Sandoval, frankly, is just shocking to me. He outwardly suggested that they're hiding the gifts and looking for other ways. That would be news to me. I know in both of them, I can't imagine they're quote unquote hiding gifts. So, you know, I think this is a huge issue for the state. I think it's a huge issue for this race. We all know that my opponent is the candidate of lobbyists. I have no support from lobbyists in Nevada. They do not help me, they do not work for me, and they work for Ross Miller. Why? Because he's been going to dinner with them, going to, as he says, banquets. They're not that big deal, it's just a charity event. They're going to boxing events, they're going to football games, baseball games. Why do all these special interests want to spend so much time with my opponent? I think that's a big issue. And that's why I pledged to not take gifts. That's why I will fight for this as an Attorney General. And I think it's a very huge deal. You know, I just want to close briefly to say that I think this office is the most important office for this coming few years. You know, the Governor Sandoval needs a partner, and we need to work to make sure that the vulnerable in this state are protected, and we need to make sure that we're working to help protect seniors from fraud and from scams. We need to make sure we're continuing the fight on human trafficking, one of a true scourge of our state. And that's why I'm proud to receive the endorsement of a statewide coalition of sheriffs and DAs that were willing to pick me and say that I am going to be the person that they believe will hold out the best for this job and do the most for Nevada. Thank you very much, and thank you for hosting this.
This is a big job, one that I'm ready for, one that I started preparing for as a criminal prosecutor, working aggressively with the most dangerous criminals in our community behind homes. Then as Secretary of State, focusing on cracking down on election law violations and administering record fines to members of both parties, working within the security division to make sure that we go after those things. I'm ready for this job. I have the only experience that's in this race to be able to get this job. I am the only candidate that has enforced Nevada law. That's why over 4,000 cops and prosecutors across this state have endorsed my candidacy, because they know that at the end of the day, I'm not going to put personal politics into my decisions. I'm going to protect Nevada's first. And that's in sharp contrast to the stance I'm going to take. So ask me to propose.
All right, I will thank both candidates for being willing to do this. Madam Laxalt, Ross Miller, show us your hand. Thank you very much. I really appreciate the time that all three of you come and took to answer questions and talk to us about issues that are important to us, and I really appreciate it. And now that you're all fired up about public records, Kelly Scott, Gazette Journal, and I are going to do a session in about 10 minutes. We'll start, we'll take a break, and be back in here for those